what's the jury thinking? It's funny, I remember I took a verdict in federal court once, and I will often be with the client when the jury comes back, and it was funny. I was standing with the clients, and I heard the one juror say, see, I told you he cared about his client. Yeah. And again, it was the bias, like, oh, he's a plaintiff's lawyer, all he cares about is winning the case and getting a contingent fee. But the jury's following all that dynamic. Right. When you have
I was just going to interject, you also run the risk of them becoming suspicious of you and thinking that you have your client here and on display because you're overreaching or, trying to impress upon them the injuries instead of letting them sort of figure it out for themselves. So you don't, even though that may not be the case, they tend to be suspicious from the outset, and rather than feed that suspicion, we would retreat from it, really.
Right. Now, in pro bono cases, I find building trust is extraordinarily important. It takes time to build that trust. And in a courtroom setting, it can be very intimidating. I had a case I did for the support center where the young man was an illegal immigrant and facing potential deportation. We were trying to get him under the custody of the family court so we could use the special immigration status to keep him from deportation. And as we were sitting over at 18th and Vine, he kept seeing kids being taken away in handcuffs. And I looked at him, and he was sort of quivering, and he thought that, I guess it's called ICE now, was going to be there and take him away in handcuffs. And so it was sort of essential to be communicating with the client all during that and making sure that they, are feeling reassured. And then that stokes their credibility as well, because you want them in a comfort zone if they're going to have to testify. And you want them seeming natural and as relaxed, quote, as they can be. I say as they can be because at the end of the day, there's nothing relaxing about being a witness in court. I've had to be a witness 3 times, and nothing worse than a lawyer witness, right? But just the idea of being there and not having control of the situation is frightening, even for somebody trained in the law.
And to follow up something that Jerry was saying about the jury keeping an eye on everything that's going on. When it's a bench trial, the judge is doing that. And specifically, you'll have a situation, again, seeing that back in the family law venue, where one party is testifying, and the judge is also keeping one eye on your client, because if your client starts to react at every single thing that the witness is saying, it's going to add credibility to the claim that your client has a temper, your client can't control himself, because that's what the client's doing in the courtroom. So you've got to prepare your client to be mindful of the fact that the judge is listening to what the witness is saying, what the other party is saying, but the judge is also watching you for your credibility while you're sitting there when you're not even saying anything.
Yeah, and what we say to our clients is from the time you leave home in the morning, assume you may be on the bus with the juror or with somebody who has some connection to the case, and certainly when you're out on your lunch break, etc. The other thing in pro bono cases is when the lawyers are up there huddling or where you're at counsel table for a long time, the client can feel like they're not part of this anymore and that they're distanced from it. I think it's very important during long periods of time to check in with the client. Even in the cases I handle, I say to my clients, you're going to see me be incredibly cordial and polite with opposing counsel. Don't let that upset you. It doesn't mean I'm not your advocate. It doesn't mean that we all just go out and have a drink afterward. Nobody really cares. I had one case where I was trying to work out a very delicate high-low settlement, and one of the defense lawyers was just a pain in the neck who I thought was going to blow the whole thing up. And so while the other 2 of my opponents were negotiating with their principals to get it done, I'm talking baseball with this guy. And I finally said to my client on a break, if you wonder why I'm over there talking about the Phillies, it's because I want to keep him over here. But it's important for the client to feel that you're there for them and to know that the things that you're doing are all in one way or another in their best interest. And I think that's part of our behavioral advocacy, and when that meshes together in a seamless way, I think we come across with a great deal more credibility. Okay, pillar number 1, credibility. We need to be credible. Pillar number 2, we need to be logical. This is less the ethics of advocacy and more of the science of advocacy. And when I say logical, what we like to do in any case is do a series of if-thens. If this is true, then the evidence should be X, Y, and Z. Do we have that evidence? If this witness is telling the truth, what should the records be saying? If this version of events is correct, then these photographs, what will they show? And at every juncture, what you need to do is compare what you've concluded you want to present as the truth about the case with the evidence, be it spoken evidence in terms of witnesses, be it written evidence in terms of documents, be it photographic evidence, or be it just your sense that something doesn't fit quite right. I've had a paralegal who's worked with me for 27 years. And any defense bar members here, she'd make a great defense paralegal. Because what she does is she rips apart every case. And every shred of document that comes, she comes in and gives me a list of, is this inconsistent? Could that be a problem? What about this entry here? I noticed there's a reference to this. And at every step along the way, she's looking for the holes in the case. And testing, is what we think true actually true? And when we meet as a team, we talk about, here's our problem, what's the vaccine? And by the vaccine, we mean what is a credible response we have as a lawyer that would take a seeming inconsistency and explain it away or resolve it. Or, if it's a real inconsistency, what does that mean about the case, and do we need to shift the direction in which we're going? There have been some cases where you'll start down a road and you'll be absolutely convinced that one version of events is true, and as more records come in, you have to stop and say, wait a minute, the problem here was not in the operating room, the problem here was actually down the road. Now, you don't get those necessarily kinds of situations in a family court proceeding, but an example would be, okay, I say this is true about my family situation. This person's abusive, they're a drug user, etc. Put yourself in the shoes of your client and say, if those facts are true, what would they be doing in their life? How would they be manifesting it? Would they be manifesting it by complaints? Would they be manifesting it by staying away from the person? And if they're not, do you need to explain that away? Do you need to explain away that maybe there's a dependency there, maybe there's a fear of leaving there? Because one way or another, you need to reconcile what it is somebody's doing with what it is they're saying. If they say this person's dangerous, why are they still there? If they're saying this person's unreliable, then why do they get support from them? And at every juncture, you need to do that if-then and test what position you're advancing with what the other side is undoubtedly going to put out there. Do you have any examples from your practice, Mike? You run this
well, actually, like I was talking with a client yesterday, and I was going through that exact situation with her because she had a concern with the father of the child having shared legal custody, which is the right to have the input on the decisions that affect the health and welfare of the child. And I said, well, that's something that in most cases the court orders that both parties will share. Why do you feel that the father should not have shared legal custody? Well, he's not going to make the right decisions. Well, it's how do you know that? Well, I just do. It's like, well, no, that's not going to work for the court. You've got to be able to give some kind of examples where either bad decisions were made or that the dad did not want to be involved. And that got her thinking, like, well, when he was showing up for the doctor's appointments, the doctor would say to him, what do you think? And he would say, well, whatever she says. I said, okay, that's something you want to bring up with the court. But you've got to be able to back it up, give examples of why you feel the client's going to take this position. On the other hand, we had a situation, this was actually a VIP case, where you think you have an understanding of the case and things take a slight turn for the worse. The child was living with dad. Dad had killed himself. And a neighbor had stepped in and was taking care of the child, and mom wanted the child back. Well, it wasn't until the attorney got into court that it was determined that the child did not want to go with the parent, that the child was very afraid to go with the parent. We don't know the reason why for this, but we had this one whole set of facts where it's this next door neighbor has stepped in and has taken this child and won't give the child over to mom and is avoiding the police. And it's like, well, the mom's in the right. And then once she gets into court, it's this neighbor has actually been very involved with the life of the child. The child does not want to go with mom. The child's afraid of being with mom, where all these facts just did not come out until we're in court. So you've got to always be able to do those reality checks to find out from the clients, why is this happening? Why isn't this happening? Why did you not get involved before, to get a sense of what's going to end up happening in the case? You can't predict it all the time, but you still have to get a sense of what's out there, what are all the realm of possibilities. You've got to do, as Jerry was saying, the if and thens.
Right.
If this is the situation, then why did this happen and why didn't this happen? And have those conversations with your client.
Another way of looking at this is, how would I attack my own case? and what would be the consequences of X, Y, and Z being true. Sometimes we don't do this as much for trial because in civil practice we've got depositions, but we'll sometimes do logic trees before a deposition and say, okay, we anticipate 3 possible answers for why X or Y happened, and let's do a separate tree for each one of those that we're ready to pursue. If the answer is it was for this reason, 1 line of questioning, for that reason another, or then a third. One of the things, and we're going to talk about, we get the witness preparation, ways of dealing with that, but let me just throw out this observation now. As people, we tend to think and communicate in conclusions. The example you just gave us is somebody had an impression and said, they're no damn good. That impression has virtually no evidentiary value. Why did you get to the conclusion that they're no damn good? Give us the incidents that show that. And we'll talk a little bit about how to take those conclusions and draw them out of your client in preparation, and how then to paint a picture, again, using facts rather than rhetoric. We've been talking about the logic aspect of a case from the standpoint of playing defense, in a sense, of testing our own case and trying to find the inconsistencies and the warts. Let me talk about logic as a matter of what I call offense, although I'm not sure that it's going to have the same relevance in pro bono cases that it does sometimes in tort cases. There are a few cases that come in, usually product liability cases, that I'll say this is really a concept case. And by that I mean it depends on one premise or another. And if we prove a certain premise is true, the rest of the case will fall in line from there. There's a famous product liability lawyer, Harry Philo, who always would try to get the manufacturer or designer of a product to make this concession. Mr. Defendant, would you agree that if there's a way to make this product so as to minimize the possibility of death or serious injury, that we should? It's a rough question. If you're the manufacturer or designer, you can't say no, can you? No, I don't care. Kill people. You have to say, yes, I agree that if we're able to do that, then we should. Now, the fundamental premise is established. If we can make it safer, we should. And then the case becomes about, well, could you make it safer? I actually had a case involving a power tool that was called the Wildcat Grinder. I love the name. I only used it once in closing. I said, look, by now you know it's no accident they call it the Wildcat. Up till then, I resisted hyperbole. But essentially, you had a grinding mechanism, but you had a lock-on button on it so that you could keep this thing rotating at an incredible rate of speed. And a couple of iron workers are working, and it kicks back, and it flies through the air and basically slices a guy's leg down to the point where he didn't lose it, but he was effectively disabled. This tool, by definition, has to be powerful, and by definition, there's some degree of danger accompanied to its use. But we committed them to the premise that if you could make it better, you should. And then we went out and we came up with a prototype guard, which combined with the dead man switch would have prevented the injury from happening. I can't really tell you whether that guard ever would have survived in commercial production. But it was a good premise, a good theory, and we had not just credible evidence, but an actual model of the device to carry the case forward. So the whole case became about, could you do this or not? And we were able to show that you could. And so think about whether you can commit the other side to a premise. So say in a child custody case, if you can get somebody to say, would you agree that if it's at all possible, it's better that the child stay with the natural mother, provided that safeguards can be made, and you get a yes to that question from whoever is testifying, then you can build your case around the premise of, well, we can put in place safeguards that will allow that to happen. And so always think about, is there an overarching concept that if you can get the other side to agree to, you can then fight the fight on your territory. And so there's certain, I won't bore you with the tort cases. I've got some fun examples of crazy cases where basically by committing the defense to the premise, we were able to move the ball downfield. But think about, is there a concept that the other side almost has to agree to? Now, when we talk about cross-examination, they're called no-lose questions. A no-lose question is one where you put it out there, and it's awfully hard for somebody to say no. So, for example, in the family law context, would you agree if it's possible that it would be in the best interest of the child to keep the child with the natural mother? Hard-pressed to say no to that without losing credibility. And so the more you can put your opponent in a position where they have to agree with your premise, then you've won half the battle. On that score, let me do a little diversion here, take a detour into issue definition, okay? So much of what we do as lawyers depends upon what the question is. What are we really fighting about in the case? There's a book by a psychiatrist who's probably crazy. His name is Thomas Saz. It's called The Myth of Mental Illness. And he's got a great quote in the beginning of it. He says, in the animal kingdom, it's eat or be eaten. And in the intellectual kingdom, it's define or be defined. And I thought about that. I said, yeah, he probably is crazy. But as a lawyer, how we define the issue makes all the difference in the world. And if we can define the issue on our terms and then make the case about that, we're far further downstream to prevailing than if we let the court or the opposing counsel define the issue. When you do motions, think long and hard about what it is you're defining the issue to be for the court to decide. And try to couch it as specifically as you can and as narrowly as you can so that the logic of what you're asking for seems self-evident. Okay, talked about being credible, talked about being logical, and the third pillar that I want to talk about here is being inspirational. I think that most juries want to do the right thing. And I also think that juries probably get it right about 80% of the time. I think most jurors take it pretty seriously. There's exceptions to that. And I think most judges want to do the right thing too. And we've all had experience with the bench. Some are better than others. But I begin with the premise that most of the time, the people who are involved in the process want to do the right thing. So at the end of the day, I always say trials are morality plays. At least jury trials are morality plays. Jury's trying to decide who are the bad guys, who are the good guys, who's deserving of winning the case, and it's very much couched in terms of right or wrong. So when we think about trying to be inspirational in a case, I always try and think in terms of right or wrong. The jury has to go back there and say, you know what, these guys are right and they're deserving. That's hard to do because let's face it, the cases that have a lot of emotional appeal, we never get to try those cases, right? The case where it's clear that the manufacturer just didn't care and they used old and worn out parts and this guy died and there were 4 guys before that who got killed, that case doesn't go to trial, right? That case settles. Or egregious cases of malpractice, okay, well the wrong limb has been, those things don't see the light of day. When we get into court, it's as I say, generally where there's 2 sides to a dispute. And so it's a lot harder to wax eloquent on some of those themes, and especially in a pro bono context. But I think when you're dealing with mortgage foreclosure, you could begin by saying, Your Honor, this is about an obligation in a contract, but it's also about whether my client gets to stay in her home, right? Never hesitate to really hit the nail on the head in terms of what's really at stake here. Your Honor, this is a serious matter. We understand that the Department of Human Services has a serious concern here, but at the end of the day, this is about a mother's right to keep her child. I always try to elevate the issue early in the presentation to a court and do it in a way that will appeal to their sense of right or wrong and humanize the dispute at the same time. There's a great book by John Noonan, who's a 9th Circuit Court of Appeals judge and who's also taught at Stanford, called Persons and Masks of the Law. And it's a short book, which is why it's a good legal book to read. And he talks about, as lawyers, we start defining people by roles: plaintiff, defendant, complainant, respondent, appellant, appellee. And behind all the verbiage are folks, right? They're people. And we're so intellectualized about it, and we deal with the stuff of life on such an intellectual level that we sometimes forget about the people behind that. And I think part of being inspirational is always going back to what's at stake here in the lives of the individuals. And in pro bono cases in particular, that's one of the things that I've tried to do. I was really lucky as a kid. I grew up in West Philly, where I still live, and there was a neighborhood lawyer who was renting behind my dad's real estate office. And I didn't find out till later my dad was paying him to hire me one summer. And I was his, quote, law clerk. But then after that, he paid me. So I got to work in a law firm for 3 years, starting in junior year in high school. And we went to a drunk driving case once, where it seemed to me we were screwed, because it was pretty clear to me that the defendant was drunk and driving. And my boss, who was an old ADA, did this long and lengthy examination of the cop, and then of this one, and then that one. And he sort of painted a picture of the fact that this guy was a commercial driver who had a family and who lived in Port Richmond, and he really needed a driver's license in order to support his family. And if he were to lose his license, he was basically going to be out of work. And the judge listens and listens and listens, and at the end of the day says, well, I find a reasonable doubt as to the guilt of the defendant. And I later said to my boss, how'd that happen? And he said, well, the judge thought about this. It was the first offense. He realized this is probably a good guy that just stayed at the bar too long that night. He said the bejesus scared out of him. He isn't going to do it again. But if he found him guilty, he would lose his license and his job. And I said, wow, that was some lawyering. It was not Oliver Wendell Holmes lawyering, but it was lawyering that managed to convey to that judge what the circumstances were and the stakes for this individual. And as a young lawyer, I learned an important lesson from that getting behind the technicalities sometimes makes a difference. That was also a bench trial, which probably helped. Okay? And we'll talk about that in a minute. So being inspirational is sometimes in the details, and I think in the average case, it's about humanizing. Sometimes in tort cases, we'll have somebody have a horrific injury and then make a great recovery. And so naturally the defense is, well, thank God it wasn't worse. And one of the ways I try and react to that, and it's not all that inspirational, is to say, well, okay, we do thank God, but it's no thanks to the defendant. But more importantly, this client's recovery is a function of the fact for the last 3 years, they've had to dedicate their time and their energy and their emotion to getting well and to coping and to overcoming. And the defense shouldn't get a credit for that. This is what this person had to make the focus of their life. So what I'm suggesting to you is we don't really get to talk in grand themes. We need to talk in the stuff of life and try to find a way to humanize the experience in a way that resonates with the person who's going to decide the case. Okay.
The flip side of that, and this ties into what Jared was saying about keeping in mind what's at stake, is sometimes what your client thinks is at stake really isn't at stake. In the family law situation, support is just about money. It's just a matter of a dollar amount. And a lot of the emotions the court really isn't too concerned about. Custody is about what is in the best interest of the child, not who is the worst person, is what's in the child's best interest. In divorce situations, it really is just money. It's assets, it's debts, it's all dollar signs. What led the parties to getting to the divorce really is not an issue to the court because grounds have already been established. So sometimes you've got to educate the client on correcting them from what they think is at stake and what the court really thinks is at stake.
All right. Who wants to talk about jury selection? Me neither. Very briefly. Jury selection is witchcraft. Why do I say that?
He's videotaped saying that,
Yeah,
so.
Right. A, you may or may not get adequate voir dire of the jury, depending upon the court that you were in and the judge that you were before. B, notwithstanding reams of material written about the subject, with rare exceptions in high-profile cases where the court really does let you sort of psychoanalyze people, you're never going to get into that depth. I've had 3 cases where jury consultants were retained by my opponent at seemingly great expense and effort. We won all 3. And talking to those folks, I don't particularly think they add a lot of value. What I think is important in jury selection is, again, behavioral advocacy. How do you initially present yourself to the jury? You need to be very sensitive to the fact that at that stage, they don't know you, they don't like you, they don't want to be there, and you're asking them personal questions about their life. And so I think you need to very delicately tiptoe into that area and make it clear why you're asking these questions, and in the way that you present yourself in jury selection, be as approachable and as low-key as you can possibly be. In terms of challenges for cause, I always say to my opponent, I would propose that we pick this jury honestly, meaning that if there's legitimately a challenge for cause on either side, we're just going to agree to that, and we're not going to play games about, oh, well, let me try to show this person could be fair to make you use a peremptory challenge, okay? I think that's a waste of time, and I think it's much better to say to your opponent, let's just do this straight up. If there's clearly a juror that's biased against one or the other, let's just agree to strike that juror. Similarly, if when we talk to a juror, we think this person is really not all here, why don't we just agree to strike that juror? I find most of the time that works. And if you keep to your part of the deal early in the process, then your opponent keeps to that part of the deal. And I think it's the best way to pick a jury. Always do the math when you're picking a jury, folks. And by that I mean you're going to get 3 or 4 peremptory challenges. Hopefully, the court will have taken care of all the challenges for hardship and cause, and then you're down to a panel of jurors who are otherwise qualified to sit. And then you need to count. Okay, what do I mean? If you're picking a jury of 6 with 2 alternates, then that's 8, and if you each have 3 strikes, that's 6 more, that's 14. You got to look, to the 14th juror and then work back from there, because any strike past that, you're just wasting. And I've sometimes seen experienced lawyers strike somebody way outside the range of where they're going to actually get seated on the jury. I always like to have somebody with me when I pick a jury. Regina has great instincts.
Try.
And ability to size up people. But even if you're going to try the case alone, it's not a bad idea to have somebody there for jury selection, both to help quickly take all the notes and to watch for vibes that you maybe are not seeing.
Yeah, just to add, I think it's essential really to have 2 people because, the one person is putting on the case and doing things and maybe dealing with the judge and other issues, so they may not be seeing what this jury panel is really doing. For instance, I was working with another partner of ours and we were selecting a jury, and I noticed that one of the gentlemen was reading the Wall Street Journal. In the particular case that we were going to be trying, that he likely would not be a favorable juror for us. And that was a helpful tip to see even what they're reading and what kind of things they, are doing. If somebody's knitting and that kind of stuff, all that plays into your, I don't really call it jury selection, but jury deselection, who you're going to try and cross off when you get to your final 12. But you really, because you don't really have an opportunity to get to know them at that juncture, any little thing you can pick up that gives you a tip about the type of person they may be could ultimately be extremely useful at the end of the day.
Maisha, are there any jury trials in mortgage foreclosure cases?
There are indeed, or at least theoretically there can be.
Huh.
Again, the plaintiff usually pushes for a bench trial. It makes sense to do an analysis of your client and determine whether your client can present well to a jury. If not, then you might want to go with that bench trial. Most foreclosure cases actually wind up settling prior to trial, which is why I'm not upfront with you right now.
But I think that goes to the point of, at an early stage, when you're conceptualizing your case, one of the things you want to ask yourself is, do I think this case is going to go better in front of a jury or not? Either party can insist on a jury. I will, in some counties and in federal court, often file non-jury. I would like to see who I'm going to draw before I make that decision. Almost invariably, the defense demands a jury. But I had at least one instance where that did not occur, and I was delighted to have a bench trial in the case. But vis-a-vis this idea of thinking downstream and testing your case in terms of the facts and credibility, I think it makes a big difference what you want to do. And I think that you can, even when judges are unhappy, you can certainly demand that jury trial. In Jersey, I know I haven't picked a jury in Jersey in a while, but I know there's Broader of voir dire. Anybody from Jersey want to share any experiences there? I understand you can talk about whether they watch Fox News and what bumper stickers they have. And
well, the one experience I can tell you is that certainly here, it's a fairly quick process in terms of picking your jury, which is another reason why it's helpful to have a second set of eyes and someone to take notes. But in New Jersey, the last case that I was over there trying with another partner of ours, which was several years ago, it literally took us a full day into like a third of the next day, which was totally unexpected, and given the nature of the case, really sort of jammed up some witnesses. But the extent of voir dire that was permissible was astonishing. Now, it was helpful in terms of learning a lot of information and trying to get certain people off the jury, but the process really took much longer, and the judge was very involved in it. So, sometimes you can learn a lot, and that might not always be favorable if you need to get your witnesses on.
all right, Mike, anything?